The meeting to order, and I'll just Pierre had his hand up for a point of order as well. So Pierre, your point of order.
Yes, thank you, Mr. Chairman. I just wanted to clarify what happened over the past week or last week, because what the committee wanted was to have the minister appear, and I hoped that we would have him here, but without having anything against the witnesses we have today, we asked for the minister to come to explain the expenditure plan, the estimates, because we have to approve it as parliamentarians. So I wonder why this morning, despite the fact that the minister has usually come to defend the estimates, has not given us a few minutes to do so this morning. So I would like to know whether we invited him, what his answer was, and why he doesn't think it's important to come here before the committee.
Order.
I do have my own point of order, but I will speak to this one at this point. I would certainly concur that would have been expected that the minister would have been here. That would be my understanding, that we should have been requesting that as well. I would like to also have an update on what was done to try to get the minister here and what the reasons were that the minister did not appear, not only at the last meeting but now at this one as well. Furthermore, to add to this, the parliamentary secretary was here at the last meeting. So the expectation would have been, if we were going to continue on the same thing, we've got all the rest of the same people here, I believe, but we do not have the parliamentary secretary either. We should have the minister, and now we don't even have a parliamentary secretary. Nobody from this government seems to want to be accountable for their decisions. You know, we could get into the whole situation that we're seeing here with a prime minister who refuses to be accountable for what he's doing.
I think we'll
it's really breaking the laws of this country.
We'll stick to this point of order.
But as per the same kind of a situation, we have now a situation where we don't have a minister here. We don't even have a parliamentary secretary here to be questioned on the actions of this government.
I can explain. Well, I can tell you that we did send a request for the minister to attend, and the minister, in her decision, thought it appropriate to send officials. I got I can't background the reasons why, but I can tell you, anticipating there would be some questions in this area, I did look back at the record over the last number of years, and often for estimates. In fact, in the previous Parliament, the minister never appeared for estimates. Whether that's right or wrong, I'm not going to say. And it is usually officials from both Finance and CRA that appeared with respect to estimates. But I can't give you an answer other than to say that the clerk sent out the request as per what the committee requested. And so we, I mean, and with an agency, we have the head of agency here, so that's pretty important as well. So. And a second point.
Just okay. On that as well, and just to kind of reclarify what you're saying. So there was a request sent to the minister, but there was no response ever received that he would appear, that he was refusing to appear. Like he just didn't have the courtesy to even bother to respond to this committee to say that he wouldn't appear.
I'll get the clerk to read the response quickly.
Yeah, just regarding the response from the ministers, it says here that I've been advised that unfortunately the minister's schedule precludes her from attending on either of the proposed dates. However, the Commissioner of Revenue and senior officials would be pleased to appear before the committee.
Okay. Did you have a second point of order?
Yes, it's in regards to the last meeting that we held. I want to get some clarification and a ruling, I guess, on this. But the way I saw the meeting play out, obviously, I think it was at 11:30 a.m. You had suspended the meeting, and I will read just a little bit from the House of Commons Procedure and Practice in just a second. If you look back at the blues, it does show that that's what happened, that you did suspend the meeting at 11:30. The meeting was never recommenced, and you did say while we were suspended, I was here, I was present, I did see you indicate that you were adjourning the meeting, but it's my belief that a meeting cannot be adjourned while it's suspended, and it was in fact suspended, so I don't believe the meeting was ever properly adjourned. Therefore, I don't believe this meeting actually is in order as we stand now, because we never adjourned the last meeting. I just want to read a couple of points from the procedure and practice, and I would ask for a ruling on this because I do think it's an important point. It's not, and I want to point out, Mr. Chair, this is not in any way intended to be any kind of an attack on you. I just want to make sure we're following proper procedure, and so I want to get a ruling so we can make sure that in the future we don't run across any thing of the same nature. So in regards to suspensions, what it indicates is that committees frequently suspend their meetings for various reasons with the intention to resume later in the day. Suspensions may last a few seconds, several hours, or span even more than one day, depending on the circumstances. And I know, as a parenthesis here, Mr. Chair, I can recall when the government was looking to try to make changes to have the Prime Minister only be held accountable one day a week, to have an extra day off for themselves every week, and all of these things where they wouldn't be held accountable to Parliament. In Procedure and House Affairs Committee, this was used quite a lot actually during that time, because that meeting of the Procedure and House Affairs Committee, I think, went on for a number of weeks, in fact, Mr. Chair, and it was suspended many times over the course of days, in fact, even. So that is, something that appears as though we're in this case where that meeting is maybe possibly still properly just suspended. So I'll continue. Depending on the circumstances, a meeting may be suspended more than once. Again, that happened in that case, as I'm aware, and I'm sure it has happened in many others. Then it continues on. The committee chair must clearly announce the suspension, which I'll note that you did do, so that the recording ceases until the meeting resumes, which never did happen. Meetings are suspended, for example, to change from public to in-camera mode, or the reverse, to enable witnesses to be seated or hear witnesses by video, to put an end to disorder, to resolve a problem with the simultaneous interpretation system, or to move from one item on the agenda to the next. Pursuant to the standing orders, the chair of a standing, special, legislative, or joint committee is required to suspend the meeting when the bells are sounded, and it goes on from there. I won't continue with that. Not really relevant to that situation. Then on adjournment. Committees most often adjourn to the call of the chair. That is, the decision as to the exact time of the next meeting is left to the discretion of the chair. This is done even when the committee has adopted a work plan that lays out a detailed schedule of meetings. In this way, the chair is given the flexibility to respond effectively to changing events and to the availability of potential witnesses. Committees may also adjourn to a specific time, as they usually do when the next meeting is scheduled for the immediate future, for example, the next day or later the same day. Committees on occasion may adjourn without making any provision for a future meeting, that is to adjourn indefinitely. And probably the most relevant part here, a committee meeting may be adjourned by the adoption of a motion to that effect. However, most meetings are adjourned more informally when the chair receives the implied consent of members to adjourn. The committee chair cannot adjourn the meeting without the consent of a majority of the members, unless the chair decides that a case of disorder or misconduct is so serious as to prevent the committee from continuing its work. And you may have made that determination at that time, but again, I don't believe we were properly constituted at that point because we had been suspended. So I certainly don't believe that there was the consent asked for or received. Again, you may have made the decision as chair to use your prerogative under the point that says that a case of disorder or misconduct is so serious as to prevent the committee from continuing its work. And I'll leave that to you to determine whether that's what you believe to be the case. But again, I will point out that I don't believe that the meeting was properly adjourned because we were in fact suspended at the time. Certainly, I know I had a number of questions, and maybe we'll get the chance. But I mean, obviously, for me, I would have preferred to have been able to question a elected member of this government because they are the ones that are supposed to be accountable for the decisions they make. We did have a parliamentary secretary here at that time. It should have been the minister, as I've indicated already. We have neither of those here now, which I think is something that I find of great concern. But having said that, I do believe this meeting is not actually properly constituted because we actually have never adjourned the previous meeting. So I would actually ask for you to give us a ruling on that, Mr. Chair.
Under Standing Order 117, and you mentioned it, that deals with in the event of disorder. And this is what it states from House Commons Procedure and Practice. In the event of disorder, the chair may suspend the meeting until order can be restored, or if the situation is considered to be so serious as to prevent the committee from continuing with its work, the meeting may be adjourned. In addition, the chair may, at his or her discretion, interrupt a member whose observations and questions are repetitive or are unrelated to the matter before the committee. If the member in question persists in making repetitive or off-topic comments, the chair can give the floor to another member. If the member refuses to yield the floor and continues talking, the chair may suspend or adjourn the meeting. So I did adjourn the meeting. On your point, about the meeting being in suspension, I don't think either of us here has an answer to that at the moment, but I will render a decision on that at a coming meeting. It is a point, and I too know when you have the deputy minister here and a parliamentary secretary, a lot of members have questions. But if the member of Carleton persists, as he has been doing, when a point of order is raised on the other side, and persists when the mic is switched off, and pushing the button here to override and yell into the mic, that is absolutely inappropriate. And I'll tell you as chair, I'm not going to put up with that kind of performance any longer. If we have to suspend the meeting 10 times during a meeting, that'll be where we'll go, because I'm not going to put up with that performance anymore, where a member constantly pushes the button to override the order that the chair is trying to impose. We can have a debate whether the question should have been allowed. I'll grant him and you that. But when there's a point of order on the other side, which there was, and the member for Carleton wouldn't allow that point of order because he consistently pushed the button, I said, that's it, a meeting adjourned. But we will render a decision on that at a future date, because we'll have to check with some procedural people to see whether I was wrong or whether I was right.
So, not to try and continue the debate, Mr. Chair, but I think it is important as well.
Yep.
Because the implication, of course, then, should that decision be that the meeting was not actually properly adjourned, is that obviously now
You're going to get a little too technical for me.
Well, these are important things,
Yeah, I know
right,
they
Mr.
are.
Chair? I mean, and so bottom line is, if that at the last meeting, if what's the meeting number 199? So if meeting number 198 was not actually properly adjourned, that means it's still actually in session, correct?
I believe it was properly
Yeah,
adjourned.
but you're
we'll have
indicating
to
that
clarify
you're indicating that you would actually have to, you're going to have to verify that and come back with a ruling on it. So now my concern is, and this is not, I want to point out, this is not in any way intended to try to prevent today's meeting from occurring. However, if we never adjourn the last meeting, how can we begin a new meeting? Do you see where I'm?
I was sitting
where
in
the
my
problem is
chair
here?
when we adjourned the meeting, and the mic was on, and the meeting was adjourned. So I'm going to operate on the principle it was adjourned, but I will seek further clarification. So with that, then we have at today's meeting 2 sessions actually from now till around about 11 o'clock. Pursuant to Standing Order 1082, study of the subject matter of interim estimates 2019-20, votes 1 and 5 under the Canada Revenue Agency. And we have with us from the Canada Revenue Agency, Mr. Hamilton, Commissioner of Revenue and Chief Executive Officer, Ms. Ram Sharan, Chief Financial Officer and Assistant Commissioner, Mr. Gallivan, Assistant Commissioner, International Large Business and Investigations Branch, and Mr. Truman, Assistant Commissioner, and Miss Frank.
She was not on the notice.
Okay, she wasn't on the notice, so I'll have to get you, Jillian, to give us what your title is, if you could.
Jillian Pranke, Deputy Assistant Commissioner, Assessment, Benefit and Service Branch.
Okay, welcome to you all, and thank you for coming. I believe, Mr. Hamilton, you've a few opening remarks, and then we'll go from there to questions. Floor is yours.
Okay, thank you, and good morning, Mr. Chair. Thank you for the opportunity to appear before the committee to present the CRA's 2018-19 Supplementary Estimates B and the 2019-20 interim estimates, and to answer any questions that you may have on either of these funding requests. I won't reintroduce everybody, as you've already done that, but I have with me today officials who can help me and answer any of the questions that you have. Mr. Chair, as you're aware, the CRA is an organization that serves Canadians and is responsible for the administration of federal and certain provincial and territorial tax programs, as well as the delivery of a number of benefit payment and other programs. L'agence s'engage.
The CRA is committed to serving millions of Canadians each year through the administration of Canada's taxes and benefits. The CRA works to administer taxes fairly and in a way that provides Canadians with the information they need to comply with their obligations. We strive to build Canadians' trust and confidence in Canada's tax and benefit administration.
Committed to improving its services and to providing Canadians a world-class administration. I would note that recently we launched the current tax filing season, and the CRA is working to ensure that Canadians know about new and updated services available to them to help them prepare their taxes. Mr. Chair, now I'll provide the committee with a brief overview of the Supplementary Estimates B and the interim estimates. First, the Supplementary Estimates B. The agency has previously tabled 2018-19 main estimates and Supplementary Estimates A, including statutory estimates such as employee benefits. Through these estimates today, Supplementary Estimates B, the Canada Revenue Agency is seeking an increase of $18.3 million in its voted and statutory authorities for the following 4 items. First, the agency is seeking $13.1 million in incremental funding to administer the federal fuel charge, including the climate action incentive. Deuxièmement, l'agence.
Second, the agency is also seeking $374,000 to respond to the recommendations of the report of the consultation panel on the political activities of charities, which includes support related to legislative changes to the Income Tax Act. This funding is primarily for outreach and communications with charities.
The agency is seeking a transfer of $2.9 million from Global Affairs Canada for the Global Knowledge Sharing Platform for tax administrations. The platform supports capacity building in developing countries and will equip them to deal with the global challenge of international tax evasion and aggressive tax avoidance. Since 2016, the agency has successfully operated a knowledge sharing platform prototype to ensure it responds to stakeholders' needs. The funding is required to develop an end-state platform modeled on the prototype. The platform will meet global expectations with respect to platform stability, information security, and serve to better support future growth and modifications. It will provide access to virtual classrooms, communities of practice, and a broad library of global best practices in tax administration. This is an example of Canadian leadership and innovation. And lastly, also included in these supplementary estimates is a statutory increase of $1.9 million for employee benefit costs associated with the additional funding from the Treasury Board submissions being sought through these estimates. If approved, these supplementary estimates would increase the agency's 2018-19 authorities to $4.6 billion. Now, the 2019-20 interim estimates. In order to begin the 2019-20 fiscal year, the Canada Revenue Agency is seeking a total of $869 million through the interim estimates. This represents the funding required to cover expected payments that will occur in the first quarter of the fiscal year for ongoing operations. The funding is being requested as part of the interim. The funding being requested as part of the interim estimates is roughly 1/4 of the voted appropriations that will be sought by CRA through the 2019-20 main estimates. Approximately $4.4 billion in total funding is anticipated through the 2019-20 main estimates. Of this amount, $3.5 billion requires approval by Parliament. The remaining $967.4 million represents statutory forecasts that do not require additional approval, such as contributions to employee benefit plans and children's special allowance payments. En conclusion,
In closing, the resources sought through these estimates will allow the Canada Revenue Agency to continue to deliver on its mission to administer tax, benefits, and other programs, and to ensure compliance on behalf of governments across Canada.
Mr. Chair, I'd be pleased to respond to any questions that you may have.
Okay, thank you, Mr. Hamilton, and we'll go to 5-minute rounds because we are running a little tighter in time than we expected. Mr. Fragascatis.
Thank you, Mr. Chair. Thank you to the witnesses and I should say the officials for being here. Thank you for serving the public. And I'm sorry about this morning's delays, but that sometimes happens at this committee and other committees. In any case, I'm quite interested in the global knowledge sharing platform. Since I only have 5 minutes, I have just a couple questions on that, though. What was learned from the prototype that you mentioned, Mr. Hamilton? I take it was started in 2016, as you said, in small form, and from there, obviously, lessons have been gained as to how to expand it. And secondly, what is the broad purpose of the global knowledge sharing platform? In the end, what are we trying to achieve with it? It sounds like a great way to facilitate contact between Canadian officials working on tax and those in the developing world. But could you go into those two things?
Yes, thank you, Mr. Chair. Just to elaborate a little bit on the knowledge sharing platform, which I might refer to as the KSP, so bear with me with that acronym. Yes, it's actually, it started a little bit before I arrived at the agency, but I would say that the people who did start it were very foresightful in what they did. And it's an example, I think, where the agency showed innovation and contributed to a broad global agenda. Currently, I am the vice chair at the Forum of Tax Administrators, which is a grouping of about 50 tax jurisdictions around the world. And one of the projects that we as Canada lead is building capacity in developing countries. And so to your question, what are we actually trying to achieve with this thing? There's a movement, and as we look at the base erosion profit sharing initiative of the OECD and the countries involved, this is imposing demands on all jurisdictions, developed and developing, to be able to have systems in place and rules to be able to better coordinate our activity as we try to battle global tax evasion. Developing countries can find particular challenges in this area, and sometimes their tax systems are not as sophisticated as ours, and so being able to implement the systems and the rules in their jurisdiction requires building their capacity up. And so as a group, as Forum of Tax Administrators, have tried to contribute in the ways that we could to transfer knowledge from us and some of the best practices that we have. Not that we're perfect, but we certainly have things to share and which should be helpful to these countries. Share those experiences with developing countries as they try to build up their tax systems. And I would just say it certainly has a benefit for developing countries to the extent that we as donors can actually help them build their tax systems, but it also helps us as developed countries and Canada in particular, because in order to run the global tax system, it works better to the extent that we have good information sharing and good coordination. So the better all of the countries' tax systems are, the better able we are to battle tax evasion on a global front. So that's the purpose of it, and it's something that, as I've said, Canada has shown leadership in. If we talk about the KSP in particular, it was started as a prototype by CRA. It's part of this broader effort, but we at CRA took the initiative to build the prototype, and we took it to the point where we could. And I would say the experience is that there's a demand for it. So lots of countries are tapping into it in its current prototype form to see what training material we might have, how they can get access to the expertise and the documents and the guidance that we have in developed countries. So this goes on. It's a web-based platform. And I think as an innovative way to transfer knowledge, different from sending a person we could send someone from Canada to these countries, and there still is a demand for that. But this
Mr.
is a way
Hamilton,
of electronically disseminating that information.
I'm sorry
so
to
countries
interrupt.
like it, and the demand is there, and so the pilot was successful, and now the step is to grow it so that it's a more stable platform that can take on more countries, more content, and be more useful.
Mr.
globally.
Hamilton,
but to do that, we have to invest in the systems and the infrastructure.
I
So
appreciate
that's
your
the state we're
passion.
at
You're
now.
clearly very passionate about it, and I can the program's merits speak for themselves. You mentioned best practices. Could you elaborate? We only have about 30 seconds left. Could you elaborate on one or two best practices that will be shared in terms of knowledge with folks in developing countries?
Well, you could think about, Mr. Chair, something like audit practices. How do you go in and audit a major multinational corporation? What are some of the things that we have learned in that regard? So that would be an example of something. What sort of system do you need to put in place? And even something like technology. What kinds of IT do you need to be able to get the information that you need and be able to use it effectively? So those would be a couple of things, really just transforming our knowledge through to these countries.
Thank you both. Mr. Richards, 5 minutes.
Thank you. I've got a few questions. Hopefully we'll have time for most, if not all of them. First one is in regards actually, I guess I want to start by just asking you if any of you have had the chance to see or to read a couple of different reports that have come out recently from organizations. One of them is the Canadian Federation of Independent Businesses February report, and the other one is Restaurant Canada's State of Alberta Industry Overview. Are you familiar with those reports, and have you read them?
Mr. Chair, familiar and aware of, yes. Do I recall the details of them at this moment? No, but I'm happy.
Well, let me just give a couple of details from them that I think are relevant, and then I've got a couple of questions that relate to it. So in the one, 87% of small and medium-sized enterprises oppose the carbon tax. 70% disagree that carbon pricing is a good way to reduce emissions and address climate change. And 83% indicated that they've already done all they can to reduce their carbon emissions, and 80% think they cannot pass those costs on to their customers. And that 71% felt that the introduction of a carbon tax will actually make it harder for them to make further investments to reduce their emissions. And in regards to the restaurants report, it indicates that about 10,000 restaurant jobs have been lost in Alberta since 2015. And that's obviously based on there's already razor-thin margins in that industry, and there is one of the biggest extra costs that's been imposed upon them, of course, is related to the carbon tax. And the fact that energy use is a pretty significant cost in restaurants, also shipping of a lot of the products they use, and they feel that in many cases that's pushing them to a point where there's just no profit margin left. And so we're being asked here to approve $11 million in new spending on this Liberal fuel charge and carbon tax. In fact, exactly what we're being asked is $10.8 million funding to administer the federal fuel charge in sub-estimates B. And further, the Department of Finance is requesting $385,000 for pricing carbon pollution and supporting clean growth. So my questioning is around that. Can you tell me why CRA is requesting almost $11 million to administer the fuel charge, and are there new regulations that require this money?
Mr. Hamilton, and I believe the figure is $13.1 million to administer the federal fuel
So it's even
charge.
worse than what I
But just so we're clear on the numbers, because they were in Mr. Hamilton's remarks, and I don't expect Mr. Hamilton will get into the policy decisions, but the decisions that the CRA must make with regard to administering the federal fuel charge. Go ahead, Mr. Hamilton. I'll not take that time from you. But
You know, actually, maybe I'll just add to that as well, because I'm not sure how much time I have left.
you got lots of time.
Okay, but just to add to that, because
I'm going to give you back the time I
No, no,
took to
no,
clarify.
that's
Let
fine.
Mr. Hamilton
Well,
answer the question first, and
actually,
then we'll come back
Mr.
to you.
Chair, I might add, because I think
Okay.
it might be helpful actually
Okay.
to allow
Go
him
ahead.
to answer all at once. So while you're sort of explaining what that request is about, can you also indicate whether you consulted with small businesses about that? And obviously, it's pretty clear, I think, with some of the stats I just read, that there's quite significant concerns among small business owners about carbon tax, about fuel charges. So could you give me some indication as to what consultation, if any, was done with small business owners and what their feeling was when this was being proposed or suggested?
Mr. Hamilton, the floor is yours.
Yes, thank you, Mr. Chair. And I will separate it into two parts. There is a question of, is carbon tax, pollution pricing the right thing to do, policy question, impacts, is not something for me at the CRA to respond to. The issue is there is a law that needs to be administered, and that's where the CRA comes in. How can we best administer the fuel charge and the climate action incentive? And so the money that we have requested is to allow us to do a professional job of administering that regime. And so 13.1 million, there's a variety of issues that we need to get in place so that we can administer these, whether it's the systems that we have to put in place to be able to record and track transactions, some of the awareness that we are putting forward to make sure that people are aware of their responsibilities and obligations, and just the ongoing costs of administration. So that's what we are asking for money for today. In terms of consultation, again, I would put it separated into two. Someone else can answer the question of what consultations took place for the development of the policy overall. For our part, we do consult with businesses about the administrative matters so that we ensure that they are aware of their obligations, and we try to take into account any issues that come up. And if you'd like to go into that more, I could ask Jeff Truman to elaborate on some of that. But that's the basic reason we're asking for the money and the CRA's role in this.
So my time is short. I
Yeah.
hope
Yeah, you're at a time, but do
Well,
you
I'll
want
let
Mr. Truman to answer, and you'll have a second round, we'll have time.
okay. Well, then, if you would allow that,
Yeah,
I would
if
love to
Mr.
hear
Truman
what-
wants
what-
to
yeah,
fully
have to say.
answer that, then there will be a second round, I'm sure.
Mr. Chair.
Go ahead.
Thank you. Yeah, just in terms of consultations with industry and businesses, we've been very cognizant of the need to reach out to industry. So since last fall, we have had a number of engagements with stakeholder groups, including the businesses themselves, industry associations, and virtually any organization for which their members would be required to register under the fuel charge. So in particular, meeting with representatives from the air, the marine, the rail, and the trucking sectors, and significant time spent as well with Canadian fuel producers and distributors. And we continue to be available for webinar, teleconference, in-person meetings as available. So we've had quite an active outreach and engagement session with them to explain the new rules and the registration requirements.
We'll have to hold it till the next round, Blake. We're over by about 2 minutes. Mr. Dussault.
Merci, Monsieur le Président.
Thank you, Mr. Chairman, and thank you to our witness for being here today. I'm pleased that the CRA was here, but we would have liked to see the minister. I'm not sure why she refused to come before the committee, but with all due respect, she generally referred questions to her officials, so maybe we are just as well off today. So I want to follow up on the last meeting we had. Mr. Gallivan, I think you probably remember the exchange on the number of convictions for tax evasion. I want to see what progress has been made since then. Have there been more convictions for foreign tax evasion? I think that we are still focusing on offshore tax evasion. We have 53 active files in this area, and this represents some $400 million in income that is undeclared. So if we go back 4 years, all of the cases were domestic, and we were talking about $12 million. And in 2017-18, we had $45 million, but it was still domestic and not international. In the future, we have an inventory that is really focused more on international tax evasion. We had a seizure in Montreal, money laundering was involved, and we have 12 joint investigations with the RCMP concerning money laundering and other serious crimes. So we have encouraging signs that the agency has changed its focus and is going in the right direction. We will continue to pursue these cases. So that's a long answer. You basically said no. It is really a yes or no question. I didn't need a 2-minute answer. Do you have any convictions for international tax evasion? But I think that behind this question, we have a principle, and that is whether we are doing things right. And I think that the answer is wrong. I think it doesn't take a magic wand. The answer is no, you don't have these convictions. I think you agree with me. I will go now to another question, which is also a status report on a different issue, and that is on KPMG. The Minister of Revenue has said repeatedly over the last 3 years that everyone would be prosecuted, there would be justice done, and that those guilty would pay the price. Can you give us an update on KPMG, not only on the clients, but also on KPMG itself and what has happened to them? Yes, there are 2 aspects to this. With respect to the clients, we have obtained the identity of all the participants at this point. We still aren't getting cooperation from some of those identified, so we are looking into that. For other cases, because of the complexity involved, the investigation is still underway. And we will continue and think that we can find all of those involved. There are cases before the courts. Some of the clients went to tax court, and it will be up to the judge to decide whether their conduct was in compliance with the act and not the agency. Concerning KPMG, we are still reviewing our options about what sanctions should be imposed. We are still gathering our facts to see what the options should be. Thank you. Well, that's some progress. I know that I have limited time, so I'm going to change topics again for my last question. It was brought to our attention that the disability tax credit, I'll give you a bit of a break on this, that this tax credit was increased by, or rather the number of rejections was increased by 60%. And because of that, some $26 million was recovered from people with disabilities who had received the tax credit. So that money was clawed back from savings accounts of people with disabilities. Can you tell me whether that's true? A 60% increase in rejections and $26 million clawed back? Can you say why there was this rapid increase in rejections?
President, je suis pas,
Mr. Chairman, I'm not sure of the figures that you mentioned. I will have to check and provide a written answer after the meeting. Generally speaking, though, about 2 years ago, we had a situation where we reviewed the number of applications for the disability tax credit, and we changed our answer in some cases. We generally accept about 80% of the applications that are made, but I will recheck the figures that you mentioned.
Ms. Wellup as well, and we'll look forward to that response. Mr. McLeod.
Thank you, Mr. Chair, and thank you to the presenters here today. As the Member of Parliament for Northwest Territories, I want to be on record saying that we know that pollution isn't free. We're seeing the costs of forest fires, the droughts and floods and extreme weather, and the impacts that it's having. And that includes impacts to our health. So we certainly know that climate change is real. We're at the forefront. We see it on a daily basis. It's happening. Can't turn a blind eye to it. We're seeing the cost of insurance to the households in the north skyrocketing. And this is concerning, not only because it's adding to the burden of running a household, but many people are just dropping the insurance, household insurance, because they can't afford it anymore. And that's to make up for the cost of all the fires that have been burning across the country, and including in Northwest Territories. We don't have a lot of merchantable timber, but a lot of it is burning, and we expect more is going to burn. We have erosion issues. Some of our communities are being washed away. We have silt a lot, quite a bit of silt, frozen silt that made up the islands in the delta, and now we're trying to stop the communities from sliding into the ocean. We're dumping gravel, and it's like driving a truck up and dumping money right into the ocean because it doesn't stay. And we've been told that there's landslides under the Beaufort Sea that are 20, 30 kilometers long. So these things are all factored into the costs of what's happening to us. And Canada has come up with a framework, and I was really happy to see the government of Northwest Territories step up and develop their own plan. And but that plan's not going to kick in until probably July of this year. So when you came forward and asked for money to administer the $10.8 million to administer the federal fuel charge, I'm just wondering if that is only applicable to the backstop jurisdictions, and if it applies to the Northwest Territories.
Thank you, Mr. Chair. Yes, I'll answer that. And I believe the short answer would be, I can't remember if it's a yes or a no. So I'll just say it does apply only to the backstop jurisdictions. And in the case of, for example, the Northwest Territories, where they have a plan that meets the standard, will be up to the Northwest Territories to decide if they would like to have a separate incentive program. And should they do that, we at CRA have the ability, and we have in the past administered programs for other provinces and territories. For example, in Alberta and BC, we do administer a rebate program for them on a cost recovery basis. So it will be up to the Northwest Territories to decide whether they want such a program, and then to talk to us about whether we would administer it. They could administer it themselves. They might have other options, but we do that, and that could be a possibility. I guess just to clarify, so that is respect to the climate action incentive or a rebate program. In terms of administering the fuel charge itself, we'll be administering that across the country. So I believe, unless Jeff would like to confirm or deny any of that, that would be my answer to your question.
Yep. So just to clarify, yeah, we will be administering the federal fuel charge in those jurisdictions where it will be applying, where the backstop is in effect. So in Saskatchewan, Manitoba, Ontario, New Brunswick.
In the event that more resources is needed to when the carbon pricing regime takes effect in the north, will this be sufficient to cover it? I'm not clear if that's the case. And are you saying that because there's going to be a carbon price offset that's included in their plan, and that's not going to come cheap to do all the calculations, and they may need the resources? How does that fit into what you're talking about here?
Mr. Chair, that would be, in terms of the rebate or the payback, that would be the subject of a discussion between us and the territory about what that looks like, how much it would cost to administer, because the design can affect the cost, and then what would our charge to the jurisdiction be to administer that program for them. But the short answer to the fuel charge side of things is yes, this money is what we believe we need to administer the charge going forward. Separate question on the rebate.
Yeah.
Okay. Mr. Miller.
Thank you, Mr. Chair, and thank you. Good to be here. I have been here before, but not very often. So anyway, thank you to the witnesses for being here. And I guess, Mr. Hamilton, this question would be for you. So how many years have you been in the public service or with CRA?
Mr. Chair, two different questions. I've been in the public service for 34 years, and I've been with CRA for just over 2 years.
Okay. I still think my question is relevant. So in your years in public service or CRA, et cetera, have you ever been exposed to a situation or a budget whereas something similar to the changes that would benefit SNC Levelland were included in the budget bill? Have you ever seen a situation like that?
Mr. Chair, I don't really have any comment off the top of my head in terms of what I've seen over the years. I spent a number of years at the Department of Finance and seen a lot of things come and go in budgets. In general, probably yes, but I would have to think about that question, about the similarity.
That's fair
I'm not
enough.
sure I have anything constructive to offer.
My last question before I turn it over to Mr. Richards, do you think that it's appropriate or relevant that changes like that be included in with a regular budget bill? Is that the right place for it?
I really have no comment on that. I have no comment on that, Mr. Chair, whether it's appropriate or not. It's for governments and Parliament to decide.
Okay, can't or won't?
Mr. Miller, I think it does relate to a policy issue that the government itself decides, and I don't think it's really fair for Mr. Hamilton to answer that. Thank you for your question. And Mr. Richards.
Yeah. I suspect the desire not to answer that probably speaks for itself, Mr. Chair. But I don't blame him for not wanting to. I would like to actually just ask about something that I have asked about before at committee and elsewhere of both the elected officials and yourself, and that is the issue of the government unfairly targeting some small businesses and that is around the rules that determine active versus passive income and how those rules are affecting some small businesses like campgrounds, mini storages, and others. But I'll focus in a bit on the campgrounds because they've seemed to have been the ones that have been the most unfairly targeted. It's a great concern to me because it's shutting down businesses, frankly. And what's happening is that these rules around active versus passive income are being used to target small businesses like campgrounds, and taking what has been in the past considered active income, and frankly should be considered active income because we're talking about businesses that provide a lot of services to their customers here, and now they're being arbitrarily assigned as being considered as passive income, and there's no doubt that work is not passive. So they're getting these huge new tax bills, and it's shut some of them right out of business. There's no question about that. That's happened. So I wondered if you could give me some sense today, because I've asked this question a number of times and not had an answer. How can the government and therefore the Canada Revenue Agency be telling some small businesses that they're too small to be a small business? Like, the ridiculousness of that statement, like, it just makes no sense to me to tell a business that they're too small to be a small business. And essentially what we're telling them, what you're telling them, is that if they've got more than 5 full-time year-round employees, they're a small business, and they can have the small business tax deduction. But if they have less than that, they're too small to be a small business. And we all know that in Canada, there is not a lot of campgrounds that are open year-round. So if they might have 5 employees even in their season, in fact, many of them do, far more than that in some cases, but they don't all have them year-round. So can you tell me why the government or the revenue agency continues to persist in trying to attack these small businesses and put them out of business? And that may not be your intention, but that's what you're doing. So why is that happening? Why is it continuing to happen? And what's being done to try and make sure that we're not affecting small businesses that are really trying to just make a living?
Okay, Mr. Chair, just to respond to that question, and again, I would split the question into 2 for appropriateness, and no one should attribute any motives to why I may or may not answer questions on the policy side. It's just not for CRA to speak to that. But in the question you've answered, there is a policy dimension about what's the right way to tax businesses, to tax active versus passive income, and the law actually has rules that dictate how that should be applied. That I'm not going to comment on. Where we come in at CRA is we take the act that is in place and figure out how to best administer it. And if the act tells us we need to do it this way, we try to find the best way possible to administer it. And so whether 5 employees or the rule is appropriate or not, I put that aside for the moment, but we have to find a way to help the business comply with their responsibilities under the act. And I would just say, in terms of our role, is to make sure we're doing that fairly and consistently with the Act. But also, we do try to make sure that there's a good communication between us and the businesses about why we're doing what we're doing and how we think the rules should apply, and have an opportunity for them to express their concerns and for us to evaluate those. So that's an ongoing process for us. And I think, frankly, if I would say that at the agency, we're trying to do that job a little bit better overall. I mean, now, outside of this case, where we do a better job of explaining how the Act operates, what our responsibility is, and why we're administering it the way we do. But certainly not with an eye to attacking small businesses. It's really with an eye to informing and making sure that we apply the law consistently.
Okay. So, Mr. Fragascatis.
Well, Mr. Chair, you indicated that I had to let him finish, and then you
We'll come back to you. We're
on,
2
Mr.
minutes.
Chair.
We're 2 minutes way over.
The reason why I chose to ask to interrupt at the
Mr.
point I did was
Fragascatis.
so
Thank
that
you,
I
Mr.
could
Chair.
Point of order, Mr. Chair. Point of order. When a member of Parliament in this committee has the floor is theirs. Mm-hmm. You indicated that you wanted to have me let him finish. Out of politeness, I did so. Having said that, I understood that my time was short, My understanding from what you had said was that you were going to give me an opportunity to ask the follow-up question that I had, and that's why I allowed that to continue. But really, that time as a member of Parliament is my time to use as I see fit. And if I felt the witness was talking with kind of the clock out, I should have had the opportunity to ask him that question. And I thought that's what you were indicating to me, was that you were going to allow that. So, Mr. Chair, can you tell me
if there's
what ruling you're making that says that I can't, as a member of Parliament, use my time as I see fit during the questioning period that I have?
The time frames that were established at our organization meeting, and I think anybody who would say that I've not been very fair with letting lots of time go over a couple of minutes and sometimes longer in order to finish a discussion, I've always done that at this committee, and I'll continue to do so. Can you put your question down to 30 seconds, and we'll let you sum it up, and then I'll go to Mr. Fragaskatis.
Oh, I certainly can, Mr.
Okay,
Chair.
get it done.
Thank you. I appreciate that. What you had mentioned about the idea of consistency with the way you're applying these, and that was actually what I wanted to follow up on. Was what some of these campgrounds are finding is that they're doing exactly what they've always done, and then all of a sudden they're being reassessed going back several years. So how does that speak to consistency?
What I'll do, in the interest of time, I'll give a brief explanation, but I think at the last meeting we also did commit to get back to you in writing, and I believe that we did that. And in terms of consistency, the way that I was using the term was to say at any given point in time, we consistently treat one taxpayer the same as another. There can be circumstances where, for a variety of reasons, something gets administered in a slightly different way based on new facts or new evidence that's come to light. And so over time, we can see some of that. So I will get back to you, though, back on this particular case, and just note that we are trying to apply the law as it should be and consistently across taxpayers. But I'll elaborate on that.
Coming to Peter, but do you have any data that would show if some campgrounds had to close down as a result of this change, or this applying the rules as they're applied now? Do you have any data to that effect that you can provide? I expect it to be difficult to come by, but.
Mr. Chair, certainly at the moment on the top of my head, no, but I'm willing to go back and see if there is anything that we have that would be helpful.
Have a look. If you could, Mr. Fragaskatis.
Thank you, Mr. Chair, and I know it's the view of at least the vast majority of the members of this committee that you have been more than reasonable, more than fair. Certainly I've been serving this committee since September, and you've always been fair, so I need to say that. Beyond that, and I will put questions to the officials on the matters at hand, but since it has already been raised, the issue of climate change, I know my colleague opposite put forward some perspectives that are now on the record, and I want to do the same. Let me read into the record the following quote. For 25 years, countless people have come to climate conferences begging our world leaders to stop emissions, and clearly that has not worked as emissions are continuing to rise. So I will not beg world leaders to care for our future. I will instead let them know change is coming, whether they like it or not. Continues. Since our leaders are behaving like children, we will have to take the responsibility they should have taken a long time ago. We have to understand what the older generation has dealt to us, what mess they have created that we have to clean up and live with. We have to make our voices heard. Now that quote comes from Greta Thunberg. Greta Thunberg is 15 years old, Mr. Chair, and I think that view needs to be put onto the record. She is a Swedish teenager. Sweden, long ago, as you know, Mr. Chair, put in place a price on pollution, and its economy is doing remarkably well. In fact, there are many studies that indicate that its economy is doing so well precisely because it has put a price on pollution, which has acted as an incentive for innovation and has helped Sweden really combat the issue of climate change and become a world leader in that regard. Canada is seeking to do the same. On what should be a nonpartisan issue, Mr. Chair, we continue to see from the opposition fear-mongering around the issue of our time. which is climate change. In fact, I would point my honourable colleague and indeed his party leader, and in fact the entire party, to not any Liberal, to not any NDP or any member of the Green Party, but to Preston Manning, who is well on the record. In fact, he's written numerous op-eds talking about how a price on pollution is necessary to combat climate change. So once and for all, I hope we can move forward in a meaningful way, either at this committee and in general terms, to dealing with the issue of climate change, because fear-mongering hasn't gotten us very far at all. Now, I do want to live up to my promise to stay on the issue of the estimates. In fact, I'd like to go back to what we discussed before, which is the whole issue of knowledge sharing and the global knowledge sharing platform. Mr. Hamilton, what countries will Canada be working with in this regard? Where are we planning on forging partnerships exactly?
Mr. Chair, just to answer that, there's two types of countries we'll be working with. We're working with other developed countries to develop the platform and design the content that would be put on it. So, another country like the U.S., European countries, and we'll be looking at how we can best design this tool to be helpful, and how do we make sure that we put the right material on it. In addition, we'll be working with developing countries, and it could be countries in Africa, Liberia, South America, really across the globe, that feel like they want to get access to this material. And the kinds of countries where, as I said earlier, we might normally think to send one of our auditors or one of our experts to go and help them design their system. So we'll be working with both of those, and we have been already, to both design the system and the content, and to make sure it's user-friendly, it's giving the countries what they demand.
Thank you very much. I have 1 minute left, so I'll continue on this issue, because I think this is underappreciated, quite frankly, the importance of ensuring that Canada is doing everything it can vis-a-vis countries in the developing world who are having, because of very complex reasons, issues around tax collection. Did we look at, in the prototype stage, for example, did we talk to other countries that have employed a similar policy in their engagements with developing countries? The United Kingdom, have they done something like this, for example? The United States, Germany, Sweden, to go back to, I like the Swedes, so.
I like Swedes too. Mr. Chair, yes, we certainly talked to all of those and other countries as we developed it. It's not that anybody else has a knowledge-sharing platform like we did, so we aren't taking something from another country and incorporating it, because it is new. It's a Canadian innovation. But certainly all of the countries that you've mentioned and more have experience in trying to build capacity in developing countries. Again, whether they send officials to help on the audit side, or technical officials to help them build their systems. There is a rich experience in developed countries, and I could call it roughly the OECD countries, in providing that kind of assistance to build capacity in developing countries. And so we learn from those to think about what is most helpful to those developing countries. On the issue of the KSP and the web-based platform, that's something new. And I think all of the countries involved, developing, are seeing this as a very useful tool, because it's obviously demand on resources to send someone somewhere for 2 weeks at a time. If you can go a long way there by putting the relevant material and manuals on the platform, it can be accessed electronically, and then you can save those in-person visits for discussions that are a bit more precise.
Thank you.
We will have to go to our next session, so I want to, on behalf of the committee, thank you, Mr. Hamilton, and all the other witnesses that came with you for providing the information you did. So we will suspend for 2 minutes and ask Mr. McGowan and Mr. Boychuk to come forward on the C-82. Meeting suspended. And we're dealing pursuant to order of reference of Monday, October 15th, 2018, Bill C-82, an act to implement a multilateral convention to implement tax treaty related measures to prevent base erosion and profit sharing. And we have with us as witnesses from the Department of Finance Mr. Trevor McGowan, who is the Director General Tax Legislation Division, who's been with us many times before, and Mr. Boychuk, who's Expert Advisor Tax Legislation Division. And I understand you're here basically to answer questions that you don't have an opening statement. So on Bill C-82 that we've had a number of witnesses before the committee, is there any questions to the witnesses from the Department of Finance before we go to clause by clause? Mr. Dussault.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I had a question. I asked this question, I'm not sure if it was last week. I believe it was to an expert from outside. But now that we have officials here, I would like to ask it again. And it deals with a confirmation that I would like to have concerning this new convention and whether it will apply once both countries ratify it. We are going through this process today in that regard. Does that mean implicitly that if a country doesn't ratify it in the next few months or years, that the convention will not apply with that country?
Monsieur Boychuk.
That is correct. The multilateral convention will only apply in circumstances where both Canada and the other country both ratify, and they've listed each other in terms of a treaty that they wish to have covered by the convention.
OK. Puis, est-ce que moi j'ai un document qui vient
I have a document, if I may, Mr. Chairman, an OECD document that shows the progress of the various countries, where they're at in adopting, ratifying the convention. I think there are only 19, if I've counted right, who have introduced and ratified the instrument. So is that about the numbers that you have as well?
A little over 20 right now. I know that Finland just recently ratified, and I think it's 20 plus right now.
OK. Puis, il y a plusieurs pays.
A number of countries, when we look at this list, I can't show it on the screen, but for parliamentary procedure reasons, but there are a number of countries who have signed the convention, I think in November 2017, or also later, October 2017 and January 2018. So there were a few ceremonial events where the convention was signed, but in many cases, nothing has been done since the signature. So what do you expect will happen with these countries that have signed and not taken any subsequent steps to ratify and implement the convention? Do you think that the situation will stay as is for the next few years?
Is that countries that are signing the MLI have indicated an intent to have it apply, which means that they will go through their domestic procedures to bring it into force and file their instruments of ratification eventually. All I can say on that is sometimes those domestic processes take some time. They take some debate. This is a complicated instrument. But no, our expectation is that those countries that are signing the MLI will eventually ratify it.
OK. Puis, vos attentes, est-ce qu'ils sont sur un...
And would you expect this to happen with a year, 5 years, 10 years? Do you have any idea? I know that this is complex. The legislative process is long, but what would your expectations be?
Speak for what other countries are doing and what their domestic procedures require and what the political situation in that country may be at any particular time. But I can say probably just as a general comment that you would normally see a ratification within a couple of years of signature.
OK. Puis, est-ce que vous pouvez confirmer?
Can you confirm what you have said in the past, that is, that the current tax conventions, and therefore the purpose of Bill C-82, that these conventions can be abused by others when they do their tax returns in Canada?
The question is about the currently enacted laws of Canada and as well as our treaty network. There are anti-abuse rules in the Income Tax Act. There's Section 245 of the Act dealing with the general anti-avoidance rule that were introduced a few years ago. that were intended to prevent the misuse or abuse through abuse of tax avoidance transactions that obtain their tax benefits through treaties. Recent case law has been developed along those lines, and so it's not to say that there's nothing in our current tax law that could address this type of planning, but the multilateral instrument is rather a coordinated international effort to address this sort of tax planning and to do so in, as I said, a coordinated and more effective way.
Donc, vous justifiez le.
So you're justifying Bill C-82 by saying that it will be more effective as a way of dealing with abuse or preventing it, but in fact there is already a section in the law about this?
There is within our general anti-avoidance rule a reference to the misuse or abuse of the provisions of a tax treaty. The multilateral instrument, just by its nature of being multilateral with the number of countries involved, amends the application of the treaties themselves in a number of important ways, and so that was considered to be an improvement upon our current system. I'll give you an example. The current general anti-avoidance rule applies where there is a misuse or an abuse of the of a treaty, and the MLI would introduce where it applies an amendment to the statement of purpose of the treaties. Currently, I think it's fair to say they generally say that they are intended to prevent double taxation. The MLI would, in very general terms, clarify that they are also intended to prevent double non-taxation or to prevent the avoidance of tax. And so that more clear and explicit articulation of the policy underlying the tax treaties is intended to be helpful and supplement our the application of both the treaty itself and domestic anti-avoidance rules like the one that I mentioned. And so it's not to say that currently we have nothing, but rather the multilateral instrument is intended to be an enhancement and an improvement upon the system, and one that's done in a coordinated multilateral way.
Le temps nous le dira si.
If you have time, could you tell me whether all the countries, for example, to take a country, Barbados, which is near the top of the list, has signed it on January the 24th, but has not gone any further. Can you tell us whether a country like that is serious? If not, the current system will be the one that applies, if I understand. It's a step in the right direction if we adopt Bill C-82, but we need to be realistic as a committee that it has limited application. It will apply only with countries that have also ratified the convention.
And that's an accurate statement on Mr. Dussault's part. Mr. Richards.
Thank you, Mr. Chair. I want to read something to you first, and then I've got a question. And I'm going to point out, Mr. Chair, that you're probably going to be a little itchy to cut me off on this. But I'm going to point out that there is a relevance here. You're going to just have to allow me a little latitude to get to it. So
go ahead.
Yesterday, when Ms. Jody Wilson-Raybould testified before the Justice Committee, I want to just read little excerpts from her testimony, and then I'll indicate why I'm asking you about this. For a period of approximately 4 months between September and December of 2018, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement with SNC-Lavalin. These events involved 11
Point of order,
people.
Mr. Chair.
Go ahead, Mr. Fragaskanis.
Is this really relevant I'll be that direct. I don't believe that it is. We're here for another
I can
purpose,
respond
and
to that point of order, Mr. Chair.
if we could continue the meeting and make use of our time.
Yeah, I'm taking Mr. Richards at his word. He did forewarn us that the statement might be seen as non-relevant, but he said it will come to relevance, so I'll give him that leeway.
Thank you, Mr. Chair, and it will, I assure you. These events involved 11 people, from the Prime Minister's office, the Privy Council office, and the office of the Minister of Finance. And these included in-person conversations, telephone calls, emails, and text messages. And then further on, she indicated, on September 19th, I spoke to Minister Morneau on this matter when we were in the House. He again stressed the need to save jobs, and I told him that engagements from his office to mine on SNC had to stop, that they were inappropriate. They did not stop. On September the 20th, my Chief of Staff had phone calls with Mr. Chin and Justin Tu, both members of the Minister of Finance's office, about DPAs and SNC. And all that's the relevant quotes, because they obviously reference the Minister of Finance or his office, and what Jody Wilson-Raybould and I think many Canadians would term as inappropriate efforts to try and advocate on behalf of SNC-Lavalin. So my question, and this is where the relevance does come in, is in relation to Bill C-82, if the Minister of Finance and his staff felt somehow compelled to inappropriately lobby and pressure the then Minister of Justice and Attorney General on this, on behalf and trying to do something to benefit SNC-Lavalin, in regards to the deferred prosecution agreements, one would have to wonder, would they then be willing to do the same on something like a Bill C-82? So the question would be, do you see anything in Bill C-82 that would potentially be of benefit to a company like SNC-Lavalin? And was there ever any representation from the Minister of Finance or his staff made to yourself or any other officials in the Department of Finance related to Bill C-82 and with relevance to SNC-Lavalin?
I can only speak to my personal knowledge, certainly not between any conversations between our minister's staff and anyone not in the department. To answer your question, I'm not aware of any mention of the SNC-Lavalin in the context of Bill C-82. You had asked, though, whether there could be any benefit under the Bill C-82 for companies like SNC-Lavalin, so Canadian companies competing abroad, and of course there would be benefits under Bill C-82 for Canadian businesses. One that comes to mind is the improved dispute resolution process contained in the bill, including the mandatory binding arbitration, which can provide certainty for affected businesses involved in tax disputes with other jurisdictions that have also adopted that standard. Not so much certainty as to what the outcome will be, but that in a binding arbitration that there will be a final resolution of a tax dispute and within a defined time period. So there are benefits certainly in this bill for Canadian businesses competing abroad, and but those are of a more general nature.
So just for certainty here, what were you indicating that you personally never had any representation made to you by the Minister of Finance or his staff about any benefits or what this might mean for SNC-Lavalin or any implications or representations on behalf of trying to benefit them? Is that what you're saying? Is that you personally didn't have any representation made to you in that regard by the Minister of Finance or his staff?
I have not, but I don't wish to overstate my involvement in the development of the multilateral instrument. I was involved in the the preparation of the legislation that is, or the bill before the committee right now. But
Is there then any way that you, I mean, obviously, especially given what you've just indicated, you may not have been the person that would have received those kinds of representations if they were made. And could you go back and provide us with an answer as to whether anyone in the department was in fact receiving these kinds of representations or lobbying from the minister or his staff on behalf of SNC Lavalin? Is that something you could get back to us on as a committee?
Just to step in here, I've heard several times now the statement of benefit SNC Lavalin. And as I understand it in all the discussions I've seen on this issue is not about anything to benefit SNC Lavalin. This issue is to implement, or the discussion was over the implementation of a remediation and agreement, which is a tool legally under the law, which would apply full penalties to SNC Lavalin in such a way, whether it's arrest of executives or fines or punishment in other ways, in such a way as it would protect the economy in those areas where SNC Lavalin operates and protect the employees and the pensions. This is not a benefit to SNC Lavalin. This would be a benefit of those innocent people who worked for SNC Lavalin when the executives did whatever they did to break the law. So I just want to make that point clear.
So I appreciate that you're choosing to engage in debate here, Mr. Chair. As the chair of the committee, I don't believe that's appropriate for you to do so, and I certainly would disagree with your characterization. That the fact that you know, I think it would actually be found by most Canadians as quite laughable, in fact, that it would be indicated in some way by any member of the Liberal government that somehow this was not to benefit SNC Lavalin.
Point of order, Mr.
When
Chair.
it's quite clear
Point
that
of
that's
order,
the case.
Mr. Fragiskatis.
My colleague, who I have gotten to know a little bit in the past 3 years, is a nice guy, so I won't dispute that. But he's taking the time up in our meeting. We're here to focus on something entirely different. We were kind enough, and you were kind enough, to give him the leeway to ask the question. He's put the question forward, and I think it's time to now move on. Now he's definitely, without question in my mind, straying into completely irrelevant territory, completely irrelevant to the proceedings.
Okay, I believe
if I can respond
yeah,
to
you
the point of
can,
order, Mr. Chair.
but I believe Mr. McGowan is going to get back to you on that information if there's any.
No, then that's
Mr.
fine.
Richards, go ahead.
And I appreciate that he will.
Mr.
I appreciate that he will do so. And really, my line of questioning had in fact ended. But of course, as chair, you decided to engage in debate, and I felt it was necessary to respond to indicate my concern around that. So really, Mr. Fragiskatis, if he has concerns, he should have had them with the comments that you were making, Mr. Chair. I was simply responding to those. Again, I will point out that I think most Canadians would find it quite laughable for anyone in the Liberal government to be suggesting that SNC Lavalin was not going to benefit from these representations being made. That was quite clear in the statements made by Ms. Wilson-Raybould yesterday, that was exactly what was attempted to be happening there.
Point of order.
Frankly,
Mr.
we're on a point
Sabara.
of order already, and I'm speaking on the point of order.
Okay, go ahead.
Mr.
You're
Chair.
right.
And so, you know, I understand that, you know, when someone steps out of line and doesn't sort of toe the line in this government, Ms. Wilson-Raybould has clearly learned that what happens when the Prime Minister isn't happy with what you have to say, that you're removed from your position. And I can understand, Mr. Chair, that you wouldn't want to see that happen to yourself. And I guess I can appreciate that was why you would want to bring that forward. However, I don't believe it was appropriate. That's just my response. To the point of
Okay,
order.
Mr. Sabara, and then I'm going to a question from Mr. Dessau, I believe, to the witnesses. Mr.
30 seconds, Mr. Chair. Thank you. Point over. I do want to put on the record that the bills C-82 and the base erosion profit shifting came forth from exhaustive negotiations between 2013 and 2015 under the prior Conservative government at that time. And now we're finally passing the legislation, or going through here in committee, and then hopefully legislation will be passed and put into place so we can ensure that Canadian corporations, all of them, much like their counterparts all over the world, benefit from this agreement, but also that Canadian citizens benefit from this agreement, that all corporations are paying their fair share of taxes. That's something that I know our side wants. I'm not sure why the other side does not see it that way or see it the way. I'll stop there, Chair.
Yeah, I
And,
don't
but
really think that
C82
was
and BIPS is.
I don't
is-
think
is
that
on
was a point
front.
of order. I think it was more to the discussion that we're supposed to be on.
As long as it's on the record, Chair.
Mr. Dussault.
Juste
Not with the intention of adding anything to this debate, because I think Mr. Richards had the merit of wanting, or in fact, what he was trying to do was to ask a question on another point, but try to relate it to this one. So, but out of respect, I would ask whether you want to have this kind of debate on here now, or do you want to have it at another time? Because you seem to be interested in the debate. I think it might be interesting for the committee to have.
With Bill C-82, and we will, if we decide to schedule that, we'll schedule it at an organization meeting, if and when. So, are we ready to go to clause by clause?
yes.
All right. Then turning to clause by clause on Bill C-82, pursuant to Standing Order 75-1, consideration of clause 1, the short title is postponed, and the chair will now go to clause 2. So, shall clause 2 carry? On division? On division. Shall clause 3 carry? On division? On division. Shall clause 4 carry? On division? Shall clause 5 carry? On division? Shall clause 6 carry? On division? Shall the schedule carry? Carried on division. Shall the short title carry? On division? On division. Shall the title carry? Agreed. Carried. Shall the bill carry? No amendments. Shall the chair report to the bill to the House? Agreed. And okay. Then that deals with C-82. Thank you, gentlemen, for coming and answering our questions. We went a little far astray on relevance there, but that's all right. And I believe you're going to get back to us with some information, Mr. McGowan. With that,
Point of order, Mr. Chair. You had indicated that maybe at a later point we would want to have some debate about the SNC-Lavalin scandal. We do have a little time. Did you want to do that now?
The problem with that, I'd love to do that, but the problem with that as chair, I can't get into the debate because I think maybe we can debate it at a time when I can get into it, because I'd love to get into that debate because jobs are important in the economy, I really believe, and pressure on a cabinet minister is normal. Mr. Fergus.
That's an interesting statement.
I would like to propose that we resume debate on the motion that was discussed at the last meeting.
You can do that if you want to. Do you need a motion? It is a motion. Okay. It's been moved. Give me your point. Give me your. I'll go to that, but I want to know what the motion is first. If we can, we'll see what the motion is first, then we'll come to your point of order, Blake. What's the motion, Greg?
The motion was on the committee's work with regard to the new study on open banking.
Okay, we were debating it at a previous meeting, and it started off as
it was
amended several times. So you're wanting to lift off the table the motion on the proposed study on open banking. That's your motion.
I think we've gotten to the main
a point of order here, and then we'll go to a vote because there's really no debate on that. Did you want to do a point of order?
Sorry. So there's no debate on what?
There's no debate
on bringing
bringing it back. It goes to a vote.
Okay.
I'm,
So before
I'm told according to the rules.
So what you're saying is that happens automatically without even a vote. Is that what you're saying?
No. What
there
I'm,
is a vote.
what I'm saying is,
Straight to a
the
vote.
motion is, it goes immediately to a vote. That's clear, right? Goes immediately, it's not debatable and goes to
Straight
a vote.
Okay. So I can go ahead with my point of order then? Is that?
Yeah, you can go ahead with your point of order.
So, I mean, obviously, my concern here is that we've had some fairly significant debate in previous meetings about this motion. My colleague on the committee, Mr. Kamek, has indicated some significant thoughts and concerns on this particular motion, and I'm not even sure exactly where we're at in terms of the amendments, some amendments, and things like that. But I do believe that when we left off on this, maybe we could start with that. Could you maybe give me some indication as to where we're at in terms of amendments, some amendments, like where is that all sitting at right now? And then I will want to finish with my point of order. But
Okay. If I could, I'll give you what the. Okay, the amendment. Do we have the original motion?
The original motion would be
Okay. No, that's resumed.
that was so that's the amended motion.
Okay.
And that's
Here's the amended motion. This is where we were at, Mr. Richards. That the Standing Committee on Finance undertake a study on open banking and report back to the House on A, whether open banking could provide benefits to Canadians, B, how potential risks related to consumer protection, privacy, cybersecurity, and financial stability could be managed, C, what steps, if any, the government should take to implement an open banking system, that the committee dedicate up to 4 meetings to the hearings of witnesses in Ottawa, that the committee examine opportunities to travel to jurisdictions that have implemented a framework for open banking, including the United Kingdom, and that the committee report its findings to the House no later than Friday, June 7, 2019. There was an amendment moved by Mr. Kamish, that the motion be amended by adding after the words open banking system the following. D, current data security risk and threats posed by domestic and foreign actors to the private data information of Canadians. E, how best the government can ameliorate such risks and threats posed to the private data of Canadians. F, the appropriateness of government bodies collecting the personal banking information of Canadians. G, the current landscape of financial services sector in Canada, the major actors, levels of competition, and sufficiency, stringency of regulations governing financial institutions. H, how the market share of Canadian banking and financial services industry compares to other jurisdictions around the world, and how an expansion of concentration of such market share might impede Canadian consumers. I, how the development of new Canadian FinTrack innovation has been advanced or curtailed by broader government policies, including but not limited to the levels of taxation imposed on small and medium-sized enterprises, corporate welfare, payroll taxes, openness to foreign direct investment, and the retention of skilled labor. J, how open banking could impact the process of applying for a loan or mortgage, and why such processes ought to be improved in Canada. K, how open banking should be prioritized for the current government, considering the Minister of Finance's mandate letter that was given to him by the Prime Minister in 2015, and the various priorities that were outlined for the Minister in this letter. L, what the appropriate level of government regulations over Canadian financial services providers ought to be, considering the history of the Canadian context as well as that of other jurisdictions around the world. And lastly, M, how the principles of financial transparency latent in the idea of open banking ought to be applied more broadly to the public accounts of the Canadian government. And that's the bill and the amendments, and we're supposed to do all that in 4 days. Okay. So.
I do still have a point.
Okay.
I just was needing to get some clarity as to where things were at there before I could move forward with my point. So then my understanding of that is then that we had you sort of gave us an indication of the original motion. There was an amendment that Mr. Fergus had made, and then the sub-amendment that you just read, the lengthy sub-amendment that Mr. Kmek put forward. That's where we're at? So
That is correct.
We would be on debate on the sub-amendment
It's an amendment, but
if we were to continue. Correct?
we would be debating the amendment of Mr. Kimmich, the last one that he just
Yes.
Right.
Well,
Which was
if
a
we
sub-amendment, was it not?
No,
it was
it was an amendment.
Oh, just an amendment.
Yep.
Yeah.
Okay, so there was two different amendments made. We were on the first amendment, and then if that one was to pass or fail, depending on what happened, we would then move to the other amendment that was proposed. Is that?
To the main motion, depending on what's going on. Okay. Could be sub-amendments too.
Okay, but bottom line is what we're currently contemplating then is Mr. Kmetch's, the lengthy amendment that the chair just read.
Yep.
Okay.
So, and the motion is to pull it off the table.
Right. Understood. So before we do that, Mr. Chair, on the point of order, I mean, obviously this is a topic where my colleague, Mr. Kmek, has had a fair bit of concern and debate around, and obviously he's made this significant amendment as a result of that. And given that the conversation's been ongoing over some period of time, and Mr. Kmek, unfortunately, I guess I'm not sure in committee if I'm allowed to refer to the presence or absence of someone.
You're not, but you shouldn't.
Okay, but regardless of that, Mr. Kmek would not have the opportunity to participate in the debate should we move forward with this.
I think you're kind of off a point of order, but
Well-
this is to pull it off the table and debate it. Correct?
Yeah, the motion of
Yeah.
Mr. Ferguson.
Yeah.
To resume debate.
To resume debate
So maybe
on
if you could
where
just let
it
me
was at.
finish
Yeah.
with the point, and you can
Go ahead.
determine whether
Go
it
ahead.
is or isn't a point of order, I guess, in your estimation. But given that he wouldn't be able to participate in the debate, should it occur now, and this, obviously is his amendment. It's quite a significant amendment. What I would ask is that in the interest of that fairness to that member, that this be something we discuss when he is able to be a part of that conversation. It's something that obviously has
I think we're now
significant concern
stretching
in
the
his
point of
amendment.
order and going to really debate and why. So I'm going.
Possibly, but I guess it's an appeal.
I hear
in
you.
a way, a point of appeal. How about that, Mr. Chair?
All right, point of appeal. The new terminology for parliamentary procedure.
We could just set
We
new
could
precedent
invent
today.
something
Yeah.
new together,
Yeah.
Mr. Richards.
Call it the Eastern Richards rule. or
Yeah.
something, yeah.
So the motion is on the floor. All those in favor of.
I guess I'm just looking for any indication on that.
Well, they have the
appeal
right
made, if
to,
anyone would-
each person has the right to vote how they see. It's on the
Okay.
floor. I got to deal with it as a question, procedurally. So all those in favor of Mr. Fergus' motions to lift the data I read and debate it. All those in favor? Opposed? Carried. So the debate is open. I'll go to Mr. Dussault, and I believe Mr. Richards said it. Mr. Richards. Okay.
Oui, c'était juste.
I think that in any case, I was on the list of speakers, so I could be the first one to speak to the motion, if you like. I just wanted to give my opinion very quickly because I felt that the debate was much too long. I think we spent more than a meeting on it should have lasted for 3. So I think given the little time that we have left to us, I want to say that I think that the objective is much too narrow. I think that all those points in the amendment really restricted the study of the committee on this open banking issue. I don't think that it is good for the committee to really restrict its study. If we have a broad motion, then we can look into the various issues. Obviously, a number were listed there, but I don't think we should adopt the amendment because we should not restrict our study just to those points.
Amendment and sub-amendment, I guess, is it? Okay, it's the amendment. And you're speaking as opposed to it. Who's next on the speaking list? Mr. Richard? Yeah.
Yeah, okay. Thanks, Mr. Chair. Yeah, and I guess I'll just, in the return to sort of the point I made prior to the vote.
Point of order.
Yeah, to the point of order, point of appeal, Richard's Easter rule, whatever you want to call it. It does concern me, obviously. It does concern me that I know this is something that my colleague, Mr. Kamek, had, obviously a great degree of interest in, to the point that he's obviously crafted an amendment that is quite lengthy, detailed, this debate has carried on over I think it's been portions of more than, I don't know, I'm not sure, it's been a couple
three meetings,
portions of 3 different meetings, which obviously indicates that there are some significant thoughts and concerns that my colleague had. I mean, I raised some, I know others on both sides raised a fair bit of debate on this as well, but certainly the person who had the greatest degree of interest in debating exactly what the motion looked like was my colleague, Mr. Kamek, and the fact that he would not be able to participate in further debate on this particular amendment and then the motion itself, if there was to be a vote on the amendment, does concern me, and I think it's I think in the interest of fairness, this shouldn't have been brought forward at this point. Not that I'm wanting to say that I don't believe this is an important study to look at by any means. I know that there are other things that some members of the committee want to be working on and looking at as well, and they're also important issues. But at the end of the day, I think it is important when someone has shown that much degree of interest, and there is an indication there that he wants to be able to have that opportunity to participate in this, for it to be brought forward, at this sort of end of meeting, without any indication that it would be a part of the agenda today.
Okay, a point of order from Mr. Fergus.
I'm very patiently listening to my colleague, Mr. Richards, but yet this is a debate that is not germane to the motion at hand. This is a debate about the debate, which I don't believe is it's not relevant to the debate.
Well, can I respond to that point of order, Mr.
Go
Chair?
ahead.
I would just ask that Mr. Richards gets to the substance of the issue.
Yeah, and I'm happy to do that. I mean, obviously the indications in my comments that I'm making presently, and I have certainly much more to say yet, but what I'm indicating presently is in relation to the motion itself, that, obviously I have a colleague here who wants the opportunity to be able to participate in this final decision, and that's not being enabled. And I think the fact that, we've brought this forward for debate here, is problematic from that perspective. And I obviously intend to get into further discussion about the amendment itself and its contents. But I think that context was important and is important to provide as part of that
we've heard the
discussion and debate.
We've heard the context. Now, if we could get into the substance.
Okay. So obviously the concerns that Mr. Kamek had, I mean, I'll go through them point by point at this time. He has brought forward this amendment, and I think I've got it correctly in front of me here now. And again, this does speak to that whole point I was making, that we've come here. There's been enough time where we've debated this. Having said that, when wasn't really a part of the agenda for today, people don't come with all the information in front of us, and because it is such a lengthy and substantive amendment, it is important that we have that our information and our materials with us and in front of us. Fortunately, I think I've been able to dig out what I think is the material here, and if I'm incorrect, I guess you'll point that out to me, Mr. Chair. But looking at the points that
Mr. Kamek has in his amendment here. And I
Clarification,
believe
Mr.
that
Chair.
the
Point of information.
What's your point of information?
I'm wondering, since the last 7 minutes now has been spent on the debate about the debate as opposed to the substance of the debate, is there a way that we can extend this by another 7 minutes?
No.
Thank you, Mr. Chair. So the first of his points, and I believe you've actually given them different lettering, but I've got it as A, the sheet I've got.
The amendment, the amendment had to, in order to be technically correct,
Yes.
there already was an A, B, C, D, so
Yes.
his A had to become a D.
His A would be a D. Okay, so just so I've got my frame here correct, I'm just going to do that real quickly, and then I'll carry on. Okay, so what would become point D then? He has here that he would like to see. These are the things he would like to see sort of included in any motion as far as giving a bit more context around what the study would look like. So he's got here current data security risks and threats posed by domestic and foreign actors to the private data information of Canadians. I mean, obviously, this is something that on this particular point, that people would obviously have concerns about, and it seems to me as a fairly relevant thing for us to be considering when we would look at something like this. I mean, even the government itself has sort of indicated that it has concerns about this in other areas of public policy. When you're talking about banking, this is an area probably that I think if there would be one area that Canadians would have the most concern about their private information, it would certainly be in this area of their banking information. I mean, we already saw that in the government's attempts to be able to grab that private banking information already from people.
I hate to interrupt you, Mr. Richards, but the time of adjournment is before us. Although that clock says 2 minutes to 1, I think it is slow. I think it's actually 1 o'clock. And maybe technical people could get that clock on the right time would be helpful. So with that, the meeting adjourned.